A valid point, Professor, and I know that Minister Fraser had mentioned to my colleague, Mr. Baber, that it was, quote, far-fetched to imagine UK-style tweet policing in Canada, and then moments later, he admitted that Bill C-9 will cover what people say on the internet. So, very quickly, is that a legitimate concern for Canadians if C-9 passes, Professor?
It's eminently legitimate, Mr. Lawton.
I refer you to the NCCM statement of October 8th in response to October 7th. Why did the NCCM statement of October 8th fail to mention the word Hamas? A day after the October 7th attack, why did your organization, in the statement that it issued, why did it not mention the word Hamas once?
By lowering the threshold for what constitutes hate speech and removal of the requirement for Attorney General consent, do you think it opens the way for potential politically motivated prosecutions?
Yes.
And do you see misgendering as being something that could attract a hate charge, the way that this government has viewed hate and the way that C-9 is worded?
Certainly.
Politically motivated prosecutions. You can lay the new hate charge on top of what is essentially civil conduct. I don't understand why this Liberal government is so obsessed with criminalizing freedom of expression.
This guy's garage. Like and subscribe.
9 of the House Commons Standing Committee on Justice and Human Rights. The committee is meeting to continue its study on Bill C-9, an act to amend the criminal code, hate propaganda, hate crime, and access to religious or cultural practices. Andrew.
Thank you to all the witnesses for your time and analysis on this. I'd like to start with you, Professor Party, and because you're joining us virtually, you didn't have the privilege of seeing the Liberal members of this committee snickering as you were talking about the Liberal government's assaults on civil liberties in the past. But I think that is important context for what we're seeing here, because in your opinion, these are not benign provisions. These are significant expansions of the power of the state to regulate thoughts and emotions and expressions, correct?
Correct, yes.
So when you look at language, and I'll ask you this as well after Professor Alford, but first, Professor Party, in your analysis of legislation in the past and your knowledge of statutes, when words are omitted from jurisprudence, that is not what codification of jurisprudence is, correct?
Correct, yes.
So explain in practice, if you are a police officer that is doing an investigation or you are a judge weighing in on this, how significant is the omission of the words extreme manifestation from the definition of hate that exists in the common law now to the one that C-9 puts in law in the criminal code?
Yes, so thank you for the question, and this is really Professor Alford's point. You have a common law, you have a jurisprudential context. The Supreme Court of Canada, in the 2012 case of Whatcott, describing what was a reasonable limit on freedom of expression. And let's just underline this: they said that this was a reasonable limit, but they also said that this is an infringement of freedom of speech. So what you have to start with in C-9 is an infringement of freedom of speech. This definition does infringe freedom of speech. That's what the Supreme Court says. Okay, so this is an infringement from a government that claims to be a government of the Charter and of rights. So we start there, and then if you fiddle with the wording, if you leave words out, if you make it detestation or vilification and not and, for example, then you are downgrading the threshold above which you need to get in order to find that this is established. Right? So it's a little bit of playing around with the words so as to appear as though you're doing exactly what the Supreme Court said, while you're not really doing that at all.
And I'll go to you on this, Professor Alford. I believe you did review the Minister of Justice's testimony on Bill C-9, and in that he said, and I'll quote directly from what the minister remarked here. He was asked about the definition. He said, "This was not an attempt to dilute the definition. It was an attempt to make good on the spirit of that definition and provide clarity to law enforcement." What is your view on the minister's characterization of his own bill, Professor Alford?
It's incorrect. And I would say that The problem is that the courts are going to look at the decision to use this particular language that omits the language from Whatcott that I cited in my testimony and say, well, that's clearly an intentional decision. You made the decision, seeing what was written in Whatcott, to leave this out. Now, the most ominous possibility here is what's going on behind the scenes, is that the government is actually seeking a ruling from the Supreme Court in due course that would lower the threshold to what they're putting forward in this bill. They're saying, well, you said that in 2013. If you uphold what we wrote into this bill, which intentionally left out some of the language that Justice Rothstein, since retired from the court, of course, included in that judgment, that you will then say that this is a reasonable limitation on freedom of speech. And I think that's particularly dangerous.
Explain to me, if you could, Professor, and I realize that hate is inherently subjective, which is the problem that we've been identifying with this, but what would the practical application be in your view? What would be captured by this new definition that isn't captured under the existing definition, just to demonstrate how this dilution and this lowering of threshold is actually happening? Or is there no way to make such a prediction right now?
Well, I think there is, Mr. Lawton. I would just say, if you look at what's happening in the United Kingdom right now, now remember, there's no entrenched right to freedom of expression in the United Kingdom. They don't have anything like the Charter, which creates that right. So there you have speech that purportedly abrogates the dignity of individuals or groups. That's the basis for complaints to the police, and arrests are being made on that basis. Now, that's what the language from Whatcott that is left out in the proposed definition of 319 sub 7 would allow, precisely that, people to make complaints that what someone's saying is hatred. And the reason why it's hatred is because it's an intentional attempt to infringe their dignity as an individual or members of a protected group. So we've seen quite a lot of this in the United Kingdom, particularly with very charged issues such as competing rights around what's called gender identity issues and women's rights, where you've had many people who felt like they were engaging in good faith, who are now the subject of visits from the police and then arrests because of the complaint that what they've said and the way that they've engaged on this issue is engaging and detrimental to the dignity of the people with whom they engage.
It's a valid point, Professor, and I know that Minister Fraser had mentioned to my colleague, Mr. Babber, that it was, quote, far-fetched to imagine UK-style tweet policing in Canada, and then moments later, he admitted that Bill C-9 will cover what people say on the internet. So very quickly, is that a legitimate concern for Canadians if C-9 passes, Professor?
It's eminently legitimate, Mr. Lawton.
Thank you.
And you spoke about the possibility of parts of it being struck down, the bill, and that in the past you had testified and something like that had occurred. What would you propose we do as parliamentarians, as people who are here to protect society, to make laws? What do you suggest with all the hate and the violence that's taking place these days?
My suggestion is that when you want to create legislation, you have to understand that it's only going to stand if it's indeed constitutional. There's no purpose in passing legislation that as soon as it encounters a constitutional challenge is going to be struck down. So you have to, if you want to address this issue of hate, craft legislation that conforms to the existing limitations in the jurisprudence of the Supreme Court of Canada. So in this case, I would just say, at minimum, you've got to go back to the definitions in the bill, particularly those found in Section 319 sub 7, as proposed by Clause 4, and have it reflect quite accurately what is said in the leading cases of the Supreme Court of Canada, particularly Whatcott, as myself and Professor Party have highlighted.
Thank you so much. My next question will be for Ms. Al-Azam. We've seen a rise in, hate-motivated threats and vandalism against mosques and other cultural centers and synagogues and other religious institutions. How meaningful is this legislation for those communities who simply want to gather and worship in peace?
I very much appreciate your question. I think, again, I can understand that the ambition behind this legislation may be very noble in attempting to address hate. But if you do it, to Professor Alford's point, if you do it in a way that's going to go beyond what you're setting out and going to infringe upon people's free speech rights, that really is a huge concern for all community members, including the community members that we're purporting to protect. And I maybe would just also note that as far as the Muslim community goes, a lot of I see day in and day out the cases that come across my desk. Just this past week, right, a violent assault on a Muslim woman in Toronto, viciously beat on the streets of Toronto. Unfortunately, those kind of obstruction provisions really don't address a lot of the real life cases that I get that come across my desk. So I think this is where it's really important to go back, have meaningful consultation, and make sure that we strike the right balance and get the right type of legislation moved forward.
It's all about balance, but what if these consultations took place, would you do differently? Would you suggest differently?
Oh, for instance, the 2.2 sub C, right? The concerns there about confusion and resemblance, certainly that should not make its way forward. You can't even train your way out of something like that. You can't train law enforcement out of something that is ambiguous in the way that it's even defined, right? To effectively criminalize confusion. So I would start off by removing those very, very obvious concerning portions, having real consultations with civil society community members, looking at whether that means looking at the definition, making sure that we get that right balance, and then making sure that what we're proposing actually addresses the real causes that we're seeing of hatred, and don't unduly restrict people's legitimate rights, as the CCLA pointed out earlier, right? Legitimate rights to free speech, free expression, and free assembly.
Thank you so much. I don't have any other questions.
Thank you. Ms. Al-Azim, you're Director of Legal Affairs for the National Council of Canadian Muslims. Is that correct?
That's correct.
I want to talk to you about Section 319. Do you know what the phrase intifada means?
Yes.
What does it mean?
Intifada means is a form of revolution.
It's a violent resistance, correct?
There are a number of different intifadas. There was a bread intifada in Egypt that came in. It was about economic revolution.
In the context of intifada against Jews in the state of Israel, intifada is violent resistance. Are you going to suggest that it doesn't involve violence?
I think it can involve violence, but I think it can also not involve. Are we really having a discussion about Arabic translation right now? I speak Arabic. Do you speak Arabic?
I speak a little bit of Arabic. So
okay.
I thank you for conceding that in that context it involves violence. So now the term intifada is shouted every day on Canada's streets, whether it's Viva Viva Intifada or Globalize the Intifada, which means bring the Intifada here to Canada. So in your view, when that is being chanted in a North York neighborhood, is that incitement to violence or not?
Let me be clear. This has always been the case of the position of the National Council of Canadian Muslims. If anybody is espousing any form of hatred against any group, and that includes anti-Semitism, Islamophobia, any other group against an identifiable group, that is incorrect.
I'm talking about the second section in 319. I'm not talking about hatred. I'm talking about incitement to violence, which is the other section. So my question to you again, if you already concede that this is violence and it is shouted on Canadian streets, do you agree with me that the chant globalize the Intifada or Viva Intifada is incitement to violence, yes or no?
I think that your question actually really belies a lot of the problems with bringing this bill forward, and I think it belies some of let's say, motivations behind bringing it at this point. I think Professor Party was referring to the convoy. We saw a number of hate slogans and hateful logos and symbols around the convoy. We saw a number of them.
Okay,
there was no attempt to bring a bill like this forward. So I think, if anything, your question is actually belying that this is meant in order to curb the civil liberties of the millions of Canadians who have taken to the streets peacefully to oppose genocide.
I'm perplexed that a Canadian lawyer somehow could justify incitement to violence. I'm also a lawyer, and I'm very perplexed by her position. Hamas is a listed terrorist entity in Canada. Do you think it should be legal to fly a Hamas flag on a Canadian street?
To be clear, this bill goes much beyond that. And
Just answer my question, please. I'm not asking beyond. I'm just asking about the flag. Should it be lawful? Should it be lawful to fly Hamas flag in North York?
I think that it really depends on a lot of different things. What's the intention of the person flying it? And again, this is why something of this nature that impacts civil liberties does need to be examined very clearly. And I'd just like to say that I did not concede that Intifada is violent. I specifically did not concede that.
All right. And if a person is chanting Intifada and they're holding a flag of a terrorist entity like Hezbollah, should that be criminalized in your view or not?
Again, my view is that this bill it's not even scratching that surface, because let me give you an example of what we've seen and my concern for this bill. Over the last year, we've seen Shia, members of the Muslim Shia community every year take to a procession, right? It's called the Arba'in, and they take to the streets.
Okay.
They took to the streets in Montreal wearing a green headband with Arabic calligraphy on it.
I wasn't asking about symbols. I'm sorry, my time is short. I only have about 30 seconds. I refer you to the NCCM statement of October 8th in response to October 7th. Why did the NCCM statement of October 8th fail to mention the word Hamas? A day after the October 7th attack, why did your organization, in the statement that it issued, why did it not mention the word Hamas once?
I don't know how that's even relevant to the provisions that we're discussing here.
Why did your statement fail to condemn the October 7th attack?
So what? So sorry. Listen. With all due respect, I think that my community has overseen the largest deadly attacks against an identifiable group in the G7 under in the past few years, and I think that I've had to attend the burial of my community members.
Do you condemn the October 7th attack? The political class
has allowed to fester, in part because of a
Ms.
lot of the
Salazin,
rhetoric
do you
that we
condemn
see
the October
online.
7th attack by Hamas? Do you condemn it?
Do you condemn Israeli genocide?
I'm asking the question.
I condemn the death of any innocent life. Do you?
Thank you, Ms. Salazin. Thank you. Thank you, Mr. Baber.
Would you agree that the government has a responsibility to ensure that Canadians live and can live and worship safely, free from fear?
Free from violence, yes, free from violence. If you fear violence because of the threat of violence, then that should be criminal. Yes, the assault, which is a threat of violence, is criminal already. It's nothing to do with C-9. We already have provisions in the criminal code that prohibit violence and the threat of violence. That is appropriate. We're not talking about that. We are talking about trying to keep people safe from some other boogeyman when violence is absent, and that is the mistake.
Thank you. So my next question goes to Al-Ziyam. Canada prides itself on diversity, inclusion, and freedom of belief. Would you agree that protecting these values require more than words, that it demands action when hate threatens our communities?
Sorry, I think that's directed towards me?
Yeah.
Sure.
Yeah, so...
Sure, yeah.
Okay, so we have seen a troubling rise in hate-motivated threat and vandalism targeting mosques and culture centers. How significant is this legislation for your community?
Thank you for your question. Again, this legislation can be potentially very significant. I do think it's really important that we strike the right balance on it and make sure that we are protecting all minorities, all identifiable people, and all Canadians, really, in a way that does not unduly restrict our civil liberties.
Thank you. And what message does this send when the Parliament stands united against hate while upholding freedom of religion and expression?
I'm sorry, I missed that question.
What message does it send when Parliament stands united against hate while upholding freedom of religion and expression?
Certainly, it sends a very powerful message. It sends an extremely powerful message.
Yeah. Thank you. I have no more.
Professor Party, by lowering the threshold for what constitutes hate speech and removal of the requirement for Attorney General consent, do you think it opens the way for potential politically motivated prosecutions?
Yes.
Can you maybe expand on how that might happen?
Well, because you will have a criminal provision that is completely uncertain in its meaning, and the people who are out there on the street will have no conception about where the line is between things that are okay and things that are not. And you don't have a check on political decisions like Professor Alford just alluded to. And so you basically have an open book. If you have the political wherewithal, the means to direct certain outcomes, then certain prosecutions, certain initiatives, then of course that's what you will do. And that is a poor way to construct the law. You are asking for trouble instead of trying to design the law so as to prevent the possibility of that kind of outcome.
Professor Party, Bill C-11, Bill C-18, Bill C-63 from the previous Parliament, and now we have C-9. What do you think it is with this Liberal government that's been in power now for over 10 years and their general aversion to free expression and persistent attempts to restrict free speech in Canada?
Well, there does seem to be a determination to make sure that the government is the one supervising people's speech. And I would like to emphasize the distinction that I alluded to earlier, which is that the proper restriction on speech in my books is one that distinguishes between violence and speech that is not violent. So it's perfectly adequate to limit speech by saying you cannot use speech to threaten violence. That makes sense, and we have that in our laws already. We had them for a long time. But all of these legislative initiatives, especially Bill 63, which was, for my money, the worst of the lot, but including C9, is attempting to cross that threshold and say, well, even if violence is not involved, even if you are not threatening violence, you're still not allowed to say certain things because we don't like it. And that's where you get into dangerous territory with freedom of speech. That begins to mean that your guarantee, your constitutional guarantee of free speech is not that at all. You can just compare the Canadian state on this to the situation in the United States. I mean, we both have, in both countries have a constitutional guarantee of free speech. In the United States, the government is not allowed constitutionally to limit speech, which here would be called hate speech. Hate speech is not a thing in the U.S. because the courts have said that is protected speech. And yet we've ended up in a situation here in the legislation that you're alluding to where the government is trying here and there and everywhere to try and limit how people talk.
Professor, what do you foresee as the worst case scenario of this bill should it pass? What is the slippery slope? Could we see people being arrested for edgy social media posts? Could we see political opponents? I have to bring up this hate speech thing. We have Liberal members of Parliament who have accused Jordan Peterson of hate speech, who have accused the recently assassinated Charlie Kirk of hate speech. Are they not, by making this accusation and then putting forward a bill like C-9, essentially calling for their political opponents to be jailed?
Yes, well, potentially. Anyway, I mean, you wouldn't want to make that accusation without some concrete information, but essentially, yes, you could see happening in Canada the kind of thing that has been happening in the UK, where the police are sent out on missions to crack down on people saying, dangerous things online. I mean, that is not the situation you want in a country that claims to be free. You do not want a political role in determining what people can say. And the Jordan Peterson case is an excellent example.
Professor Alford, I have 30 seconds with you. You talked about the potential for this bill to violate the charter and be struck down. I did a documentary on free speech a couple years ago. There was a 5-4 decision that almost basically fined a comedian for telling a joke. How confident are you in the current makeup of Canada's Supreme Court to uphold free expression rights in Canada?
So the Ward decision that you alluded to would have completely changed the framework for the evaluation of reasonable limitations on freedom of speech. It was extremely troubling to see that it was considered a close question by a number of the justices. So I would really have strong fears that were this to come to the Supreme Court of Canada, that they would reevaluate that framework with the idea of balancing freedom of speech against some other compelling objective that would really be fundamentally dangerous to the democratic accountability and legitimacy of the government, and indeed our constitutional state.
Thank you.
Professor Party, you mentioned that people should be allowed to hate and allowed to say that you do hate. And in a way, as long as they don't encourage violence, I guess people can hate. As long as they don't incite, I guess they're allowed to say that they hate. I don't disagree with you. We can morally say that's wrong. For example, one of the things that you once said, Canadians have been sold a bill of goods. Many of them think that they have a right to equal treatment under the law. They think that discrimination is illegal, but nothing could be further from the truth. In Canada, discrimination is lawful as long as it is committed against the right groups, and in particular against straight white men. I think we can both agree that many people might disagree with what you just said there, but I don't know that you would argue that this bill would allow anyone to decide that that would be hate speech, would you? You wouldn't imply that this bill is going so far as to criminalize that type of speech, are you?
I'm sorry, to criminalize what kind of speech?
The speech like you just made, the speech where you declared that, for example, straight white men were the ones that were discriminated against in Canada. That you're not arguing that this type of law would stop you from saying that, are you?
I don't think I would go quite that far. What you're reading from is a legal analysis. So if we get to a place in this country where doing a legal analysis is criminal, then we're in really bad shape. But I wouldn't have jumped to there. No.
Okay. So Professor Alford, can I ask you a question? You had talked, and rightly so, about there's always a balance, right? I agree. The Charter Statement should make clear that this is a clear violation of Section 2. There is no doubt. And the question is whether it's saved under Section 1. And there are restrictions on freedom of speech that can be saved under Section 1, as Keekstra said, as other cases have said. And there must be a limit where, for example, my right to freedom of speech blocks someone else from exercising their right to freedom of speech. For example, if I intimidate or obstruct someone from entering into their place of worship, so they have no longer a right to practice their religion freely, we can't say for sure how a court will rule, but it is a legitimate decision of the legislator to determine that that would be consistent with a Section 1 limitation of Section 2 rights. Would you not agree, Professor Alford?
I do agree, and I would say the reason why I agree is because there we're talking about what are frequently labeled time, place, and manner restrictions that don't talk about the content of the speech. So therefore, it's far more likely to say it's a legitimate restriction because we're not making this discrimination on the kind of speech which is involved. But I think that what you're pointing to is the kind of thing that we should be crafting rather than talking about particular types of speech or the intentions behind speech.
Totally understood, and I appreciate that discussion. I take note of your point under 319 and the definition.
Madame Bussière, I'd like to ask you about C-9's approach to hate symbols. Now, you would agree that under the current law, someone who displays a hate symbol, and I'm using broadly the definition, let's say, that C-9 uses, could be charged under Section 319 right now, correct?
Effectivement, il y a différentes dispositions du Code criminel qui peuvent être utilisées.
Yes, various provisions of the criminal code could be used when symbols are used. All will depend on the context. One of our questions concerning the provision is to look whether we are already repeating something that already exists in the criminal code.
Believe that as worded now, Bill C-9 would make the display of a symbol on its own a criminal offense, or do you believe that it is just part of the context that could lead to a hate charge?
C'est intéressant parce qu'il y a une tension par rapport à ça dans la manière.
It's interesting. The way we read the text may be different from the way the minister has presented it. He said it's not complete prohibition of any display of a symbol. But when we read the text, it's not very clear. We seem to associate the fact that there's a desire to incite hatred and the fact of displaying a terrorist or a symbol of terrorism or hatred. But there are already criminal consequences if symbols of terrorism are displayed or symbols of hate, but all will depend on the context.
You shared that, Madame Bussière, because this is us with the hate definition, another example then of where the minister's description of the law actually differs from the law itself.
Ben, il y a certainement une tension. Après ça, à partir du moment où...
There is some tension, but the courts will have to interpret it and they will refer to the text, to the context, to the objective of the legislation and the intention of the legislator, what was said and what was presented. So I cannot give you a final answer to the question, but when you read the text, it raises some questions.
Professor Party, I'd like to return to you on this. Are you aware that the Ontario Human Rights Commission views misgendering someone, identifying them as the wrong gender, to be discrimination and to be against the law of the Ontario Human Rights Code?
Yes.
So when we saw Bill C-16 in a previous parliament, this was the bill that led Jordan Peterson to speak out so vocally on this. This was expanding Canadian human rights law to include gender identity and effectively embedding in Canadian human rights law the very similar provisions that we have in various provincial human rights codes, correct?
Correct.
So I realize the Canadian Human Rights Act does not itself tie to the criminal code, but it does give a sense of where the government wants to go with this, especially looking at Bill C-63, the Online Harms Act from the previous parliament. And do you see misgendering as being something that could attract a hate charge, the way that this government has viewed hate and the way that C-9 is worded?
Certainly. Potentially. Sure. There's no reason to think not.
And that is, to go back to the UK case, precisely what a lot of people are finding themselves receiving the knock on the door from a British constable over. It's them tweeting something that has waged into gender. Now, again, I do not take, in the purpose of our discussion on C9, the view that this committee needs to weigh in on this, but it is a live issue that people should be able to freely debate. So when the state is deciding what constitutes hate, my question is, what are the implications on limiting the ability to hash out controversial subjects in society?
Well, they could be devastating. Yes. So there's back when C-16 was being debated, I was a witness at one of the Senate committee meetings, and one of the senators in that meeting said to me, "Well, look, I'm a free speech guy, but this requiring people to use proper pronouns is just reasonable speech. It's reasonable speech, and therefore it's reasonable legislation." And that completely misconceives the whole idea. The job of the government is not to legislate reasonable speech. If you had a statute that said Canadians will be required to say hello and please and thank you, because that's reasonable speech, that is totalitarian. Because speech is something that people decide for themselves. And so as long as the government thinks that its role is to make sure that people are speaking reasonably, then you're totally off on the wrong track. People's speech is their own unless, for my money, unless they are threatening violence. And if you're over that threshold, you're going to get into the potential for the kinds of problems that you are alluding to. And that potential is very, very real.
Okay. Well, appropriately, thank you.
Ms. Elazem, in recent media articles, Stephen Brown, the Chief Executive Officer of the National Council of Canadian Muslims, said being generally supportive of Bill C-9, noting that his organization has lingering concerns, and I'm quoting, over how the law will be applied and whether law enforcement will properly distinguish between what does and does not count as hate symbol. Can you explain to us what is the scope of hate crime affecting the Muslim community in Canada, and to what extent is it linked to Islamophobia?
Well, it's certainly linked, and the scope is such that I didn't even know about that public statement, because every day I'm busy kind of dealing with the calls that we get day in and day out of Muslims across this country who have suffered from a variety of hate crimes, including just this week, 2 assaults, again, a woman brutally beat on the streets of Toronto. So certainly we see, I think that's what your question was getting at, we see hate crimes of that are unfortunately only gaining in numbers, and they don't seem to be letting up, and in all facets of life. And really, it's as Muslims are just participating in public life, walking down the street, accessing a grocery store, driving out of a parking lot.
How is it, like, if you could explain to us how it is directly linked to Islamophobia? How those hate crimes are directly linked to Islamophobia? Yes.
Well, certainly it is. certainly the crimes, I could draw you some direct links of, if somebody's punching you and saying something very, very viscerally anti-Muslim, right, then that's very clear that this culture and climate of Islamophobia enables and emboldens people to be able to behave in that way.
With the legal department, can you give us an idea of how many incidents you've received of this type of hate crime or Islamophobia over the last couple of months or perhaps the last year?
I think we've received well over 700 in the last year. We do a report annually to, I just don't have the numbers, sorry, off the top of my head. That's something I do go and revisit it annually, but I just don't have it off the top of my head. But I can tell you, I get at least one call a day of these types of incidences.
Your opening remarks, you spoke about wanting to be consulted. Were you not aware that, all communities, including the Muslim community, were consulted over the course of the summer with regards to the issue of Bill C-9? Were you not, or maybe your organization, consulted? I just want to be clear on that.
Yeah, to clarify, no, I appreciate the opportunity. To clarify, I said consulted about the full contents. While we were consulted, and we've had many consultations with governments about, for example, the freestanding hate provisions for many years. The parts, for example, about Section 2.2, for example, that's something that was completely a surprise. There's lots of elements of the bill, and that's why I said the full contents of the bill. Because it would have been nice, I think, to have proper consultation with all the communities that are impacted, not just by the bill, but that the bill purports to protect.
Parts of the bill were you consulted on during the course of the summer?
I believe it was the freestanding hate crime provision and perhaps the obstruction offense. To be honest, I wasn't personally consulted, so I'd have to go back and check. It wasn't me that was in those consultations.
Okay, but you do recognize that the Muslim community was consulted?
On certain elements of it, right?
Okay.
But the elements that we weren't are the elements that we take a severe problem with, right? That we have severe concerns.
Which is your
raising.
Section 2.2.
Exactly.
Okay. And can you share with the committee how Bill C-9, if passed, would affect the Canadian Muslim community?
Sure. I mean, I can give you the example of the Shia procession that I was trying to describe earlier, of Shia Muslims who participate in the Arba'in procession and walk with a green headband. And that happened just last year, and a bunch of bigots took to the internet taking photos of young children who were participating in that procession. Again, it's not a political rally. There's no political speech involved. It's purely a religious observance, and a number of bigots took to the internet posting photos of those children and saying that they are, young Hamas or they're being trained or engaging in some kind of terrorist activity.
Thank you, Ms.
And this is where yep, no problem.
I understand that in your opinion, if I say that we need to exterminate all political, liberal and conservative political organizers because I lost my election, that could be acceptable even if I'm asking them to be killed.
No, that's not true. So there's going to be a problem here where speech is not just hate speech, it's actually a threat. And what you're describing there is potentially a threat to the lives of other people.
When I read out, deal with the enemies of the people, count them and exterminate them, don't you think that's a threat of violence?
Potentially.
No, that's it,
yes.
Mr. Party, thank you.
To be honest, I would like to see
Mr. Party, thank you.
For myself. But
Mr. Baber, it's over to you.
Potentially, yeah.
No,
Sir, what's the problem with my question? You don't like it?
No, I think your question is totally fine. I think you've asked it 8 times. Mr. Baber, over to you.
Mr. Party, I'll permit you to answer for my friend's benefit. The call in Montreal was for extermination of the Zionists, or supposedly a prayer for extermination of the Zionists. Do you believe that that is protected speech?
No, in the abstract, if you say to me, if you call for the death of people, whether it's particular people or a group of people, that in my books is not okay. So I don't think you should be able to hide behind the context of that advocacy. I hope that answers your question.
Thank you. Professor Party, I'd like to talk about a few elements of the bill that haven't spoken, that have yet to be addressed today.
Yes.
The new criminal hate offense can be laid in response to any offense contrary to any act of Parliament. Is that correct?
Right. Sounds like it, yep.
Yeah, so in other words, you can predicate the standalone criminal hate offense on conduct that is not necessarily criminal.
Sure, that's correct. That's possible. Yep.
So, for instance, you could suggest that non-payment of wages under the Canada Labour Code, if it is motivated by hate, could lead to a criminal charge.
Correct.
You could suggest that if someone's engaged in the suppression of votes under the Canada Elections Act, that could lead to a criminal charge.
Yes.
I find that very, very concerning.
So do I.
Especially given that the government appears to, in fact, seeks to lower the bar to convict of hate, and at the same time as removing the safeguard of the Attorney General. Would you recommend that we confine the application of the standalone hate offense to offenses that are truly criminal in nature?
Well, first, yes, absolutely. But second, I would recommend that you get rid of it altogether. And that's because what you are now doing, even if you limit it to criminal offenses, you are setting up two tiers of violent offenses. So let's compare two things. Let's say somebody assaults two different people, and one of them, they just choose somebody randomly on the street, or they pick somebody that they know. And in the second case, they pick somebody because of their identity. And in both cases, they do exactly the same thing. They beat them up. Okay? Both of those things are wrong. They're both offenses, and they're both equal because the amount of violence is equal. And what we're doing now is saying, well, one of those is more serious than the other one. No, they're both serious, they're both violent, they're both wrong.
If a person intimidates someone while obstructing them from entry into a religious institution or an educational institution, isn't that already illegal? Isn't that already criminal?
Yes, it is criminal if there's any kind of intimidation or violence involved, in the sense that we have criminal code offenses that can be applied there, and if those offenses do not apply because the elements are not there, then all you're talking about probably is speech, and speech should be fine.
I would think that if you're intimidating someone while obstructing them from entering a premise, that would be assault.
You think so? Yes, if you have actual obstruction, if you are standing in the way and you're moving around to make sure that they can't get around you and yelling in their face, then that sounds like a criminal code offense that we already have. Yes.
Professor Party, I look at this bill overall. The government is lowering the bar for what hate speech is. It's removing the safeguard of the Attorney General consent, potentially opening folks to politically motivated prosecutions. You can lay the new hate charge on top of what is essentially civil conduct. I don't understand why this Liberal government is so obsessed with criminalizing freedom of expression.
I don't either. I wish I knew.
You mentioned being perturbed by a certain line of questioning today, and you were cut off. Would you like to elaborate a little bit on that?
Certainly, I find it really concerning that the Muslim woman in the room was the one who was consistently asked to condemn Hamas and talk about terrorist actions, et cetera, et cetera. I think this proximity, this like constant association of Muslims to being proximate to terror, is part and parcel of exactly the kind of thing that I mentioned in the in our initial submissions, which is that we've seen for 2 decades exactly as how that line of thinking and that kind of viewing of Muslim Canadians has really impacted our not just sense of citizenship, but that we end up being over-policed and under-protected.
So when my colleague Ms. Latanzio was asking you about every day you're getting a phone call, you mentioned during your testimony, of somebody being attacked on the base of their race, the way they look. Can you talk to us a little bit about the difference? Has there been a big increase in the last years that you've seen in violent acts committed against people in your community? And what kind of difference between previous attacks and these ones have you seen?
I would definitely say that there is certainly an increase. It's been an overwhelming increase for our organization to be able to address. In terms of the nature or the violence of those acts, no, unfortunately, it's not worse because we saw in in the Quebec mosque shooting, and that was how many years ago. We saw the our London family terror attack, and that was how many years ago. We saw what happened in mosques in Toronto, a caretaker at a mosque in Toronto being killed, and that was many years ago. So I can't say that they've increased in intensity, because I don't think you can increase in intensity when you're already starting line is murder. But in terms of the frequency, I'm certainly seeing an increase in frequency and an increase in regular assaults as people are just going about their days totally unprovoked, and alongside it, Islamophobic remarks or comments, etc. It certainly adds to this general phenomenon of feeling over-policed and underprotected, certainly.
And it was just mentioned before that beating up somebody is beating up somebody, and they merit, the same prosecution. That if somebody's being beaten up because they are, and somebody on the basis of the way they look, what do you have to say about that?
Certainly, the underlying maybe action is the same, but in terms of the impact that may have on a community, as a community organization that delivers community impact statements regularly in criminal sentencing matters, I can definitely assure the members of this committee that it does have real impacts. And I was I'm a Londoner. I was in the room when Nathaniel Veltman was sentenced. I was in the room when his actions were declared terrorism. And I was in the room a full gallery of Londoners who still are still dealing with the impacts of those actions and how it ends up impacting their sense of belonging. And it's not just Muslims. It impacts we heard from a number of vulnerable community members and community groups how it impacted their sense of belonging.
Thank you.